Welcome back to Pace Immigration, paceimmigration.com, talking once again with immigration lawyer Michael O'Rourke. Michael, good to see you.
Hey, Sean, how's it going?
Going well. I've got the immigration mailbag is open once again. We take questions from around the internet that end up on our YouTube page or in the emails. Of course, we don't say anyone's names, and if there's any kind of information that might identify someone, we blot that out. But the stuff I have for you today was published publicly on our YouTube page. So people want the answers, and we're going to give them to them. So we've got stuff from criminal convictions, marriage sponsorship, J Treaty. I know you love that.
Love the J Treaty.
And a lot more. So let's jump right in with question number one. Here's a question, and we get a lot of these with the criminal record stuff. It says, 12 years ago, I got assault and trafficking weed convictions. I want to drive again to the States. The drive tells me this might be outside chance it's Mexico, but it's sounding like it's probably Canada.
Likely Canada.
Right.
But regardless, the thing that jumps out at me is the trafficking conviction. So U.S. inadmissibility is usually focused around whether you've been convicted or not, except for in the case of drug trafficking, where all they have to have is a suspicion that you've committed it. If you've actually been admitted, or if you either admit to it or you've been convicted of it, the penalties will still apply. And drug trafficking is one of the things that the U.S. is very serious about. So it is very difficult to get a waiver of this inadmissibility. Things that can help is showing rehabilitation. If the actual conviction happened very far back in time, if there are records to prove how much, say, marijuana was being trafficked, it's very fact dependent, but drug trafficking convictions are very difficult to get waived. So
Right.
It might not work. Assault, on the other hand, that is also very factually dependent. If it's assault against say a domestic partner, loved one, or child, then that gets ratcheted up in level of severity versus just like a punch in a bar room or something like that. So assault is something that could be on its own basis a something that would keep this person out. It might not, but the trafficking conviction is the thing that would worry me most.
Right. I mean, as soon as I saw it too, it's a trafficking weed conviction. I was like, it's going to be an uphill battle if it's a battle that you're willing to fight.
Exactly.
Okay, let's go on to question number two from the immigration mailbag. What happens if the USA citizen spouse does not sign the paperwork for the permanent green card for his spouse? This one, I don't know what's going on behind the scenes here, and this was all that was written in the message, but sometimes you get some people maybe with some cold feet about weddings or about marriages, or they think, if I don't do this, then the person isn't allowed to stay and they'll be removed from the country. This sounds like it's in that vein, Michael.
Yeah, so parsing this, sign the permanent green card, paperwork for the permanent green card, that to me says there's already been a conditional green card based on the marriage that's been issued, and they're probably now moving 2 years later to lift the conditions. The spouse, the foreign citizen spouse, the green card holder, could file on their own, especially if they've been divorced or separated, and with an explanation of what's happening. If this is an initial green card application and the citizen spouse won't sign it, you're in a much worse position. However, if there have been things, and we're assuming facts, not in evidence, but if there's been like any sort of domestic abuse or something like that, Violence Against Women's Act Violence Against Women Act might come in and play a role and provide a pathway to green card. It's going to be very factually specific how we would look at this, but don't give up all hope. There might be some sort of recourse.
Right. What about looking at it from the other end? If it's someone saying, well, I'm not going to sign it, therefore all my problems are gone now.
Well, it depends on what stage in the process you're at. If you've already committed to sponsoring your spouse and they've gotten the conditional green card, you're on the hook anyway for that undertaking of saying that you will be a guarantor for them for the next so many years. So it's not that easy to
Right.
get rid of that obligation.
Yeah, the time to ask whether or not it's a good idea is before the vows, before
Yeah, seriously.
getting married, and then once it's done, because we've discussed that before, haven't we? Sort of go on a bit of a tangent on this, but we've discussed it before that just because you get divorced, you're still on the hook for that sponsorship.
Exactly.
Right. Okay, let's carry on to the next question we have here. Can you help my brother apply for humanitarian parole? He has a serious illness and is in need of treatment. First, sorry to hear about your brother and what's going on in your family. But Michael, from an immigration point of view, we don't spend a lot of time talking about humanitarian parole. Perhaps you can address it here.
Yeah. So if the writer is in Canada or Mexico, you can apply directly to the CBP port director to ask if they'll allow the person in. And of course, you're going to have a lot of proof. Why should they not stand in line for a visa? Why shouldn't they go through USCIS? It is a way to do it. Sometimes it works, sometimes it doesn't. It's definitely at the discretion of the port director. If the writer needs a visa and is outside of our land borders, ports of entry, then they would have to apply through USCIS. Again, you're going to need a ton of documentation, especially in case of serious illness and medical treatment, whether that treatment is available in the home country. That's often a big decisional factor. But yes, we do humanitarian parole cases from time to time. Happy to have a chat about it.
Okay. Thank you for that, Michael. Next one I've got for you. This one's a bit of a long one, but I wanted to give you we always say it depends on the facts, and I was trying to include as much as I could. So I quoted the whole message here that we got. It says, I want to travel to the US for a holiday with my friend in a group with others. However, she was charged with child abandonment and neglect for leaving her child home alone, for which she was convicted.
Okay.
It says here, I think it was 13 years ago, and she was a young adult at the time. Will this make her inadmissible? The child wasn't physically harmed in any way. One thing I did want to flag, it says she was a young adult at the time. So if she was a minor herself, like 16, 17 years old as a mother, will that make a difference? I turn this over to you, Michael.
So if she was convicted as a juvenile, then it probably would not be considered as creating an inadmissibility for her as an adult. But we don't know the age. Assuming that she was an adult, or say 18, or whatever the age of majority in her home country was at the time, child neglect, child abandonment, those are considered crimes against or crimes involving moral turpitude. So they would require some sort of waiver to come into the US. 13 years ago, that is a good start. There's a Supreme Court case called Haranka where they list factors, recency and severity of the crime charged, and whether there's been rehabilitation. I mean, we would have to look at the specific facts to know if she would have a chance. I think there is a possibility that the person who had neglected and abandoned their child could get a waiver. There's also a strong possibility she could be turned around when she comes to the U.S. if she doesn't have a waiver.
Right. So, it's interesting to see people that write in for their friends or for their relatives, right? Like, yeah. It's almost like they're like, wait a minute, there's someone in the group that's smart enough to say this might go badly for us.
Yeah, so just make sure that if you're going to travel in a group, you have separate airline reservations, then she's not going to be the designated driver because she might not be coming in.
Right, right. Make sure if you are like roommates, make sure the hotel isn't in her name and all that stuff. Yeah.
Exactly.
Okay. Carrying on with the next question I have for you here. I was given a summons to go to court for allegations of assault with bodily harm for a dispute between me and another person. I was not arrested or convicted. The case was sent to mediation and was successful, and it was dismissed. Record is clean, they say. Can that affect my immigrant visa, Michael?
Yes and no. So yes, in that you have to always disclose charges, and if there was a summons, there was a charge. Charges, arrests, convictions on your DS-260 as part of your immigrant visa application. It is a must, and if you don't disclose that, then you could be denied the immigrant visa for misrepresentation or concealing important facts. So disclose it. Talk about how the charges were dismissed. Talk about the whole pathway and how it came to be dismissed by the court. Will it affect the issuance of the immigrant visa? It might not, because it has been dismissed before there was any sort of conviction. That, of course, is going to be up to USCIS and the officer issuing the immigrant visa. It likely, if you disclose it and it was indeed dismissed and you're able to provide all of the paperwork showing that, it likely is not going to stop the issuance of the immigrant visa, but it is very important to disclose it, even if it didn't result in a conviction.
Right. We hear this one a lot along with like pardons and expungement and things like that. Those things are of concern, like maybe getting a job or something in your home country. But when it comes to immigration, they want to know.
Yeah, exactly. And either a pardon or a record suspension here in Canada or an expungement, those don't have any effect on an immigration application. Everything has to be put out there. So if you were pardoned or your record was suspended for X conviction, still disclose it. I know this is veering a little bit off of the facts here, but it's always better to disclose and explain than it is to discount it or not put it into your application.
Right. I mean, from their point of view, I think CBP or USCIS, I mean, they're going to err on the side of if you didn't disclose it, that means you were hiding it.
Right, exactly.
Right. Okay, let's go to the next one here. We have, and this one's close to your heart, Michael. I had to make sure I got a J Treaty question in here for you. I have here, I am a member of a Metis Nation in Canada, and I'm currently in the United States. I have my Metis Card. Do I need a blood quantum as well? I was of the understanding that my Metis Card was proof of at least 50% native blood. Can you clarify? And Michael, we should state the reason we're talking about blood quantums and things is because the J Treaty requires 50% blood quantum in order for someone from Canada to go and live and work in the United States, correct?
Right. So the Métis occupy a special area of problems within the J Treaty. Yes, you're going to have your Métis Nation or whatever band you're most closely associated with issue a blood quantum letter. That is the only thing that the U.S. actually recognizes to prove 50% indigenous blood. Unfortunately, in Canada, a lot of our bands and nations just don't do that. We kind of got beyond that level of blood belonging concept. So that's the first part. But the even more difficult part about Métis folks is that USCIS uses an old, outdated list of recognized bands and tribes, using the US word, and nations in Canada. A lot of Métis nations aren't on that. So even if you do get the blood quantum letter, even though you have your card, you still might not be able to get an appointment with USCIS to do the paperwork for your permanent residence, because they don't recognize or your Metis Nation might not be on their old outdated list. So this is something that we've unfortunately run into a couple times now, and it is very difficult for Métis folks, even though they should theoretically be included, even though the Canadian government recognizes them. The US government, I don't know when their list came into being, where they got it, how they got it, but it's not accurate and it's not current.
Would you suggest then, talking to you, you can still put together a package, try and get things done before someone goes to the border?
Yeah, definitely.
Okay. That's great. Thank you for that. Michael, that's all I have for you today out of the Immigration Mailbag. Criminal convictions, marriage sponsorship, J treat. Why am I having trouble with J treaty today? We talk about it enough times. It's like I know John J.
Yeah.
Thanks for this, Michael. M. O'Rourke at pacelawfirm.com for any questions that you have that you'd like to submit privately. Michael will get back to you for sure. If you would like to visit the YouTube channel or any of our social media and leave some comments there, we always take a look at them and we always do respond. Michael, thanks for this. We're recording this almost the weekend, so have a great weekend and we'll talk to you next week.
Thanks so much. Thanks so much, Sean. You have a great weekend too.
We're both stumbling.
Yeah, we really are. I had a big Turkish lunch and now I'm ready to just go to sleep. So
time for some Turkish coffee then. Okay.
Yes,
have a great day, Michael. Bye-bye.
You too. Bye-bye.